Okay. Hi, everyone. My name is Mark Cook. I'm an attorney with the ACLU of Washington. Very happy to be here virtually talking about marijuana laws and the intersection of kind of the continuing federal prohibition of marijuana and then state laws that permit certain uses of marijuana. Before I go further, just want to note my email there, mcook@aclu-y.org, if you have any questions or want to chat about these issues any further. But this presentation, which I think should take about 20-25 minutes, is going to cover a few things. It's going to cover, sort of the history of Washington State's kind of current marijuana policy framework, a little background on that, then sort of federal responses to states taking different approaches to marijuana policy. And then we'll sort of end with this legal issue of federal preemption, which is what can be applied when there are sort of conflicts between federal and state laws. So going to start with some history before Initiative 502 passed in 2012 in Washington State. And that Initiative 502 was the ballot measure that made adult marijuana use and regulated marijuana in the state of Washington legal. But it really didn't start in 2012, kind of this push for different approaches to marijuana. So just in Washington State, if you go back to 1998, there was a medical marijuana measure that was passed by voters, which authorized certain uses of marijuana for medicinal purposes. That was followed up in 2003 when the city of Seattle voters passed something called the lowest law enforcement priority policy that said that, sort of low-level adult marijuana use should be law enforcement's lowest level priority. Then you started to see sort of legislative proposals and reforms to the medical marijuana laws leading up to 2011. There were also efforts to do sort of depenalization or decriminalization, which were, designed to sort of have a non-criminal response to even recreational marijuana for adults. And it was around that same time that you saw changing federal priorities as well in terms of how they would approach states that had more permissive laws. And just to give you some sense is that, states didn't just legalize marijuana overnight. It was really a long-term effort by many people and sort of an evolving standard of the law. So Initiative 502 itself, so if you were a voter here in Washington State in 2012, this was the ballot question. This measure would license and regulate marijuana production, distribution, and possession for persons over 21, remove state law criminal and civil penalties for activities that it authorizes, tax marijuana sales, and earmark marijuana-related revenues. And that still is a good short summary of how Washington's law works and how most other state marijuana laws work. For people 21 and over, removes state law penalties, doesn't change federal law, taxes it and sort of regulates the marketplace. So to get into a little more detail, again, under state law, it's decriminalized possession of limited amounts of marijuana for adults 21 and older. So that's really important that the law says specifically certain activities are lawful for state law purposes, and none of these state laws had changed federal law. The federal law is clear that basically any use of marijuana continues to be a crime at the federal level. So there really is this sort of at least legal tension in that marijuana is not legalized federally, but it is lawful under Washington state law. So then the way Washington approached it is they created sort of a three-tier license system for producers, processors, and retailers, overseeing what was then called the Washington State Liquor Control Board. They now actually call themselves the Washington State Liquor and Cannabis Board. And I502 is really modeled on sort of Washington State's old hard alcohol laws, if you can recall, going back to the state-owned liquor stores. So that's really the model to kind of have this tiered system of producers, processors, and then standalone retail locations that just sell marijuana products. There was also an intention to try to not allow local bans. which was sort of an unsettled question in the beginning. It's sort of now been settled via the legislature that local jurisdictions can ban certain marijuana practices in the state of Washington, but it's really not been a huge issue because enough local jurisdictions across the state, permit, everything, including retail sales. And then there's really a robust regulatory structure to govern marijuana commerce, right? Including, things like what kind of advertising is permitted or not, how much can be grown, what are sort of the safety and security requirements for businesses. So a very robust regulatory scheme over top of all of this. There was a tax imposed, right? So about a 37%, excise tax imposed at the retail level, in addition to sales taxes, and then earmarks for some of that tax revenue to go to specific purposes. The law also had a DUI provision built into it that created a per se threshold for, if you have a certain amount of marijuana in your bloodstream and you're driving, similar to sort of an alcohol one. That was not beloved by a lot of people when that was in the law, and I believe there's actually some litigation currently pending on how that works. And at the time, it did not amend the state's medical marijuana law, which also exists in the state of Washington, although that structure was changed quite a bit a couple of years after I502 passed. This is kind of a dense slide, but it shows that earmark structure, at least as it was originally intended to work. So big chunks of money from the excise tax are to go to things like youth drug prevention and prevention practices, kind of public education about marijuana and the legitimate risks and harms that come from it. One thing I always want to note is marijuana is not a totally harmless substance, right? And I502 did not take that lightly, and in fact really tried to push back against any potential negative consequences that could come from marijuana. A fair amount of money went to just administering the programs and the regulations for it. There was money dedicated to evaluation and research on the law. A good chunk was to go to healthcare, and then the general fund sort of got the remainder. And the dollar amounts at this point are quite significant. So, in fiscal year 2019, there was almost $400 million that the state of Washington collected via excise tax, sales tax, and fees and revenues. So, I think one thing to keep in mind when you're talking about federal prohibition, right, is that the state of Washington is collecting a lot of money on what are federal crimes every time somebody goes to a marijuana retail store here. There are now hundreds of licensed retailers and producers across the state that make this system work. And as mentioned, there are stores in most counties at this point, but some local bans continue. And in some parts of the state, you probably would have to drive a fair distance to find a store. And then just have this sort of old data point about age compliance checks, but that's one of the things that you can do with a regulated marketplace is actually go into those stores and make sure they're following the rules. This is from a Seattle Times article from a couple of years ago that sort of dug into what the I502 earmarked funding is actually going to and some of the disconnects between those. I think kind of the biggest one, which is frankly not surprising in my opinion, is that the legislature has been putting more of the excise tax dollars into the general fund than the original earmark structure intended for things like prevention and public education purposes. But ultimately, all the money is at the whims of the state legislature. But the earmark structure is at least in place. A few years ago, when the money finally started to come into the state, there were attempts to do away with the earmark structure entirely, which ACLU Washington and many other groups pushed back on because some of those dollars are going to important things. Mentioned evaluation of the policy. So the measure itself provides funding to the Washington State Institute for Public Policy to really try to do a comprehensive cost-benefit evaluation of the implementation in terms of what's happened. They've put out a couple of reports thus far, which shows some very interesting things. I don't think they've been able to answer all the questions that the initiative called them to look at, but appreciate it's difficult to do that research. And then they are tasked with a couple of follow-up reports that will be coming out as soon as 2022. And then there's been a variety of, academic and sort of third-party evaluations of the law thus far, which, again, I would say is a benefit of having kind of more out in the open and regulated laws where you can really study what's going on versus prohibition model where it's very difficult to study marketplace and how the public health outcomes stem from those. So just a little bit of kind of impact. This is a slide that I think is very important from sort of a criminal legal reform perspective. And this is looking at, marijuana filings for adults, at the year the I502 passed and then the next year, and you see this massive drop, right? So, there were several thousand low-level marijuana arrests for adults happening in Washington every year. And because I502 made that non-criminal under state law, you see this massive drop almost immediately. One other theme, though, that we haven't touched on, has been the really racially disparate enforcement of the war on drugs generally. This graph shows that there was disparity sort of before I502 in terms of who was, being charged with these crimes. And then if you look, following the law's implementation, you see this huge drop overall in the number of filings, but the racial disparity, persists. And also wanted to note, that in terms of marketplace equity issues for marijuana is something that I think Washington State is now trying to address somewhat and making the marketplace more equitable and making it easier for people that had been negatively impacted by the criminal aspects of marijuana laws to get into the marketplace. And as somebody that worked on the I502 campaign and the policy itself at the time, that's something that we really failed at, was making a more inclusive marketplace at the get-go. So I just want to be totally upfront about some of the shortcomings and the work done to try to remedy some of that. This is a dense slide kind of going to the evaluation again, but I wanted to just put it up there in terms of what are some of the impacts on youth, right, and young people in particular about these state marijuana law changes. This only goes through 2014, but it's basically showing that I would say the sky really isn't falling in terms of having a huge increase in youth marijuana use, right? This is just one measure, but it's pretty consistent nationwide where there's now a variety of marijuana laws similar to Washington's that you haven't seen huge uptakes in kind of at least lifetime or infrequent marijuana use. I think there's some evidence that there can be more heavy users, which is concerning. But the notion that the sky was going to fall and everybody was just going to start using much, much more because of these laws has not been the case. Politically, I502 passed, I think, roughly 56% of the vote or so in 2012. And some of the research has shown that, support for it has, if anything, kind of gone up. So this is a cite to one study that was sort of doing time point survey data, and at least going back to 2016, almost 80% of voters in Washington were sort of okay with marijuana legalization. So there hasn't been sort of a political backlash to the measure either, at least in Washington. So turning now sort of to the federal response to all of this, and I will say that, when Washington and Colorado became the first two states to pass these laws in 2012, nobody really knew what was going to kind of come next in terms of the federal response. But want to start with this famous quote from Justice Brandeis, it is one of the happy incidents of the federal system that a single courageous state may, if its citizens choose, serve as a laboratory and try novel and social and economic experiments without risk to the rest of the country. So this is, sometimes sort of paraphrased as the laboratory of the states. And I think marijuana policy is a really great example of that in action. And that sort of resulted in this map. So this comes from an advocacy organization called Marijuana Policy Project. This is a 2021 state map, which shows all of the different types of laws that are now in effect. And sort of the darker blue color are full legalization states for adults 21 and over. And, you know, I mentioned Washington and Colorado were the first in 2012. You now see, you know, quite a few have fully legalized. And several of those, you know, sort of passed now through the legislature. In addition to legalization, you have medical marijuana states, you have states that have some form of decriminalization or depenalization for low-level possession. And really the exception to the norm now is the handful of states there in white that don't have any type of marijuana policy. So the notion that because it's illegal at the federal level, meaning states can't do it, is really no longer reality. And the trend is very much towards more permissive medical marijuana policies or regular legalized marijuana policies. But going back, you know, a few years, even before I502 in 2012, with the Obama administration, you started to see sort of a change at the federal level. So there are a couple of memos that are historical and important for all of this. So starting in 2009, you had something called the Ogden Memo, which said about state laws that DOJ should not focus resources on individuals in clear and unambiguous compliance with existing state laws, meaning more deference to states. It was around then you really started to see some of these more gray market medical marijuana industries really popping up. They even tried to walk that back a bit with this 2011 Coal Memo. Persons who are in the business of cultivating, selling, or distributing marijuana, and those who knowingly facilitate such activities are in violation of the Controlled Substances Act, regardless of state law. You know, since I think there were some people concerned about the proliferation of medical marijuana commerce in certain states. But then you get post the 2012 elections, and many of us were very interested to see what the federal response would be. And this quote from President Obama to Barbara Walters really, I think, kind of sums it up. It would not make sense for us to see a top priority is going after recreational users in states that have determined that it's legal. We've got bigger fish to fry, you know, and that really could be kind of the shorthand response to what has the federal, you know, response or not into these state laws, is that apparently they have had bigger fish to fry. They did come out with some guidance to states in 2013. This is sometimes called the Coal Memo. Prosecutors should weigh all evidence, including but not limited to whether the operation is demonstrably in compliance with a strong and effective state regulatory system. They went on to identify 8 enforcement priorities. So they were concerned about things like distribution to minors, revenue going to criminals, out-of-state diversion, use of state laws cover for criminals, violence and firearms and marijuana businesses, driving under the influence, public health harms, you know, marijuana growing on public lands, marijuana possession on federal land. And kind of going to that intersection of state and federal law, the federal government has never said that, you know, they don't have the ability to enforce their law whenever they want. And that continues to be true. The federal government would be within its right to, you know, arrest anybody in possession or selling or using. But for, you know, kind of political and discretionary reasons, they are choosing not to shut these laws down via their own federal power. So there was, you know, question marks going into a new administration in 2016. Attorney General Sessions, who was originally with the Trump administration, was, you know, very, you know, kind of record of being pretty tough on crime, pro-war on drugs. You know, he did rescind some of that previous guidance and said, previous nationwide guidance specific to marijuana enforcement is unnecessary and is rescinded. So that kind of formal, you know, structure at the federal level was removed. But then when you got down to the local sort of U.S. attorney level, you got quotes like this from then acting U.S. Attorney Annette Hayes in the Western District. U.S. attorneys are in the best position to address public safety in their districts. U.S. Attorney Harrington over in Eastern Washington, U.S. attorneys are in the best position to weigh all relevant considerations. So even though there was sort of a change at the top, you didn't see sort of a new interest, at least locally, in trying to shut these laws down because of the federal law. And then this is just from last month, April 20th, the White House press corps has a sense of humor in terms of asking this question to the White House about sort of the Biden administration's approach to this. And this was the response from the White House spokesperson, Jen Psaki. The president supports leaving decisions regarding legalization for recreational use up to the states, rescheduling cannabis as a Schedule II drug so researchers can study its positive and negative impacts. And at the federal level, he supports decriminalizing marijuana use and automatically expunging any prior criminal records. He also supports legalizing medical marijuana. So you wouldn't have gotten a comment like that even out of the Obama administration, years ago. So the needle has definitely moved at the federal level too. But there still is this kind of legal question out there of like, well, how is it that Washington state can have this, legal marijuana marketplace and yet it's still illegal federally? How does that work? And the answer is that there's actually way more conflicts, and it's much more common to have kind of conflicting state and federal laws than I think a lot of people realize, and that it's only in certain instances where kind of conflicts between the two rise to a certain level that courts need to sort of sort out that question. And this is kind of roughly, considered the federal preemption doctrine in terms of how you sort of adjudicate those situations. And I think kind of a good starting point for understanding federal preemption is, where does it ultimately come from? So it comes from our US Constitution. There is a supremacy clause in the US Constitution that says the laws of the United States shall be the supreme law of the land. Anything in the Constitution or laws of any state to the contrary notwithstanding. But that's counterbalanced with the 10th Amendment, which says the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. And the reality is that when you're talking about kind of practice of medicine, law and order, kind of police practices, those are traditionally state law issues, right? And that's why you have, very different approaches to those type of things from state to state. But, in certain instances, the federal law can be the supreme law of the land, but there has to be some specific factors in place for that to occur. This is kind of a blurry slide, but if you want sort of the rough structure of how federal preemption can then be applied in different contexts, this is sort of a rough diagram of that. There's kind of two broad categories of federal preemption: express and then implied. And express preemption, I think, would be, something that very clearly is a power delineated to the federal government, and they are expressly going to, set all the rules for that. And then the kind of harder to interpret prong is this implied preemption, which then gets into all these different sort of applications where there's this notion of field preemption, where basically the federal government has preempted an entire field of a subject matter. And then there's kind of this conflict preemption where a lot of the litigation lies in terms of are the two laws in conflict and which one should win out. And then even that prong can go into kind of two different tests, whether this kind of direct conflict or impossibility test, or is there an obstacle conflict, which is basically does the state law frustrate the purposes of the federal law? And there can be arguments about which test should even apply in certain instances. So for this case, or hypothetical case, if somebody wanted to shut down state laws based on federal preemption, you'd be looking at this bottom two categories of direct or obstacle conflict preemption, and there would be arguments about which one should apply. And then you would also be looking at a statutory section in the Federal Controlled Substances Act, which governs kind of federal drug law. And there's some specific language in there so that there is no conflict with state law unless there is a positive conflict between that provision of this subchapter and that state law, so that the two cannot consistently stand together. So I think a good reading of that is that the federal government has not preempted like the entire field of this. It's a concurrent jurisdiction situation where lots of state laws on this, lots of different approaches to drug law, and the federal law anticipates that and says, unless there is this, kind of positive conflict, right, that really makes it so the two cannot consistently stand together, that the state law, is okay. And then sort of added on to this, is this kind of 10th Amendment issue, which is kind of a subpart of that, is called the Anticommandeering doctrine, right? Which says, in a nutshell, that the federal government can't force a state to sort of adopt or enforce federal laws. And here's a couple cases if you want to read up on it in more detail. And one was just from a couple years ago, Murphy v. NCAA, which was about state level gambling on sports. But in that case, it was held that it is as if federal officers were installed in state legislative chambers and were armed with the authority to stop legislators from voting on any offending proposals. A more direct affront to state sovereignty is not easy to imagine. So in the marijuana case, I think, basically what the 10th Amendment is important to remember is Washington state doesn't have to have any marijuana law on the books at all. It could say, we're going to treat marijuana like, a pine tree or something, literally, that there's no state law on this, whatever, right? You can have as much as you want, you can do kind of whatever you want with it for state law purposes. And that would clearly be constitutional, right? The federal government can't say, Washington, you need to have a specific marijuana law, and the 10th Amendment prevent that. But, you could arguably say, oh, some of these regulatory provisions and Washington's marijuana law, kind of conflict with what the federal law is trying to do, which is, prohibit most uses of marijuana. But it kind of puts you in this interesting conundrum, which I think is well illustrated by this exchange between the Deputy Attorney General Cole, previously with the Department of Justice, and Senator Leahy from Vermont when they were talking about this issue. And DOJ says it would be very challenging lawsuit to bring to preempt the state's decriminalization law, right? So that's basically admitting that, yeah, the 10th Amendment means we can't force states to have marijuana be criminal. Goes on to say, we might have an easier time with the regulatory scheme and preemption, but then what you have is legalized marijuana and no enforcement mechanism within the state to try and regulate it. And that's probably not a good situation to have. Senator Leahy says, kind of an incentive for a black market, isn't it? Yes, very much so, sir. And money going into organized criminal enterprises instead of going into state tax coffers and having the state regulate from a seed to sale basis what happens to it. So this really, I think, kind of shows that, maybe somebody could bring a federal preemption challenge against these state laws and kind of win on those technicalities, but then you just have sort of decriminalized, unregulated marketplaces, which, could have a lot of side effects that people wouldn't like. But that's kind of really where it's been. So there was never sort of a formal challenge by the federal government to get these laws invalidated. Again, with the caveat that they've always reserved the right to enforce their own law if they so choose. But we're still in a bit of, tension where the federal prohibition and the state laws appear. So, things like business tax deductions, aren't allowed. That's the 280E issue. Banking is a tough one, right? Where it's hard for marijuana businesses to kind of have regular banking services. It continues to be hard to research marijuana. And then kind of the changing political winds are all still there. You're starting to see more federal legislative attempts to try to kind of deal with some of those issues, to kind of harmonize the federal law with the local laws. There were a series of lawsuits that were brought over the years to try to shut down some of these state laws. There were something called civil RICO lawsuits filed in Colorado against some of those businesses, which haven't had a ton of impact. There was an interesting original jurisdiction case, which is kind of a case that would go directly to the US Supreme Court that was brought by Nebraska and Oklahoma against Colorado. And that case was rejected from the US Supreme Court, basically arguing that there really wasn't an injury to litigate there, but there were some attempts to try to push back on these state laws. And then, kind of wanted to end with some of the other ones, but I mentioned federal legislation. Lots of bills get introduced now. One called the MORE Act actually passed the House last December, I think, which was the first time that there was kind of a one chamber actually passing legislation. So, I think that will continue to be an issue that you'll see federal action on, and possibly some type of at least budget action or a specific bill passing not too far out would be my guess. And then you've continued to see more states, legalizing. Point you back to that map a few slides ago. Really, a lot of marijuana laws on the books now. I always love this John Boehner quote, the former speaker, said a couple of years ago, "My thinking on cannabis has evolved." He now happens to be a board member of a marijuana investment business. Even former AG Bill Barr was saying, in 2019, "I'm not going to go after companies that relied on the Coal Memoranda." And then the last point here, really is that as much as this is interesting legally speaking and kind of what's the discretion of law enforcement, the politics really overlay all of this. And I think that's even more true now than it was in 2012, where in 2020, you had 4 states pass marijuana legalization measures, and even a place like Mississippi passed a medical marijuana law. So sort of the public support for at least allowing states to have the laws that they want really seems to have won the day on this issue. I suppose, things could change, but at this point, I think the likelihood of the federal government's trying to come shut these billion-dollar industries down now is pretty unlikely. Although there is still a disconnect, right? It's still illegal at the federal level to possess and use and sell marijuana, but it is permitted under Washington state law and now under many other state laws to this day. So that is the end of this presentation. If you'd like to learn more about the ACLU Washington, there's our web link. And then again, there is my email. I'm happy to answer questions. And thank you so much for taking the time to watch this video.